Good evening and welcome to this evening's seminar, Know Your Lease. My name is Graham Walker and your presenters this evening are me, Tim Rayner and Ben Gildner. All of us are members of the Irwin Mitchell property team. I will commence proceedings by discussing leases and funding. I will then hand over to Tim, who will deal with security of tenure, and then Ben will conclude with the telecom agreements. We'll take questions at the end, and if you have any questions, please do not hesitate to put them on the question and answer chat. So what we'll be dealing with this evening will be leases and funding, lease renewals, and telecoms. So next slide, please. And further. So what are we going to deal with in this section? These are the important aspects. How do you occupy? Do you actually occupy under a lease? Do you occupy with another organisation, perhaps a cricket club or hockey club? If so, how is that arranged, managed or regulated? Why is your lease so restrictive? Do you have typical lease provisions which will impact on funding and development? And importantly, what are the solutions available? And I'll also touch on trustee liability. Next slide, please. So what basis do you occupy the premises? Is it a lease? Now the legal basis of your occupation will be crucial, as any funder will require your occupation to be by way of a lease with a sufficient period of time remaining on the lease. Therefore, right at the beginning, you just need to check your lease, locate the lease and see where you are. It is possible that you're actually occupying by an arrangement which isn't a lease, and that will cause problems regarding funding. You may be occupying under an arrangement that gives you a lesser degree of security, for example, a mere license, or even a tenancy at will. And Tim will deal in more detail with that section later in the evening. Another important aspect is, do you actually occupy with a third party? So, for example, you may share the land with another body, a cricket club or a hockey club, and therefore you need to consider how that arrangement is managed and regulated. In many cases, several sporting and community bodies have joined together to form an association, and typically the parties have an overreaching entity, usually a company limited by guarantee, who will actually be the leaseholder. And sitting under that, you'll have a rugby section, maybe a cricket section. So there will be regulated within the overarching agreement, usually in the memorandum of association or the objects of the association, rules regulating the governance of the association. Therefore, you need to establish fairly early on what any internal resolutions and procedures need to be obtained and undertaken to enable you to get final sign-off to allow the proposed development and funding to proceed. Turning now to what is the purpose of the lease? Well, the lease is the contract between the landlord and the tenant regulating the use of the land. It gives the tenant exclusive use and enjoyment of the land for the agreed length of time of the lease. It also governs the rights and liabilities of the landlord and tenant in relation to matters such as liability for rent and repairs. And most importantly, for the purposes of obtaining funding, it sets out any limitations or obligations as to conduct, use and occupation by the tenant. So why is the lease so restrictive? The primary purpose of restrictions in the lease is to preserve the value and the condition of the land on the basis it will at some time in the future return to the landlord. For example, it will impose repairing covenants, and covenants restricting development and alterations to the land. However, certain leases are more restrictive than others. For example, because the rent is at a low rent or a nominal rent which is less than market value. And increasingly you find with local authority leases is a situation, particularly in respect to recreation grounds, is where the local authority is the freeholder of the land, but they actually hold the land as trustee with regard to a trust. As I said, this is fairly common on recreation grounds. So typically in the past, a local benefactor will have given or sold the land to be used for a specific purpose. and the trusts under which the land is held are fairly restrictive. Say only part of the land can be developed for a pavilion, or a large percentage it has to be used for recreation for the general public. Therefore, the lease terms will reflect the restrictive nature of the trusts. The trust may in fact be a charity trust, in which case charity commission consent may be required for any development or anything which is outside the scope of the trust. So let's examine the key clauses which may impact on funding. It should be noted all the clauses we're about to examine are standard clauses found in a lease. However, it is the scope of each clause in your particular lease which may be the issue. And we will deal with the solutions a bit later on. So, permitted use. Now, most leases will contain a covenant by the tenant restricting the use of the land for a particular use or prohibiting the use of the land for certain specific purposes. Now, such covenants will vary from lease to lease, and their effect will depend upon the precise wording. The funder's concern is that he'll require comfort that the scope of that restrictive clause is sufficient to permit the purposes which the funding is made for. So therefore, the permitted use clause needs to be examined. Charging. The funder will more often not secure the funding by way of a charge or mortgage over the club's leasehold estate. Now, you may ask the question, well, can I actually grant a mortgage over a lease? Well, the answer is yes. It's very similar to your house. You get a mortgage from the building society or the bank, and that's a charge of the freehold interest. Well, a leasehold interest can also be charged as well. And generally, particularly if it's a substantial amount of money, the funder will be looking to charge the property to secure that funding. Now, the lease will either totally prohibit any granting of charges or will allow charges subject to the consent of the landlord, which is not to be unreasonably withheld or delayed. Now, forfeiture clauses. All leases will contain a clause which allows the landlord in certain specific circumstances to terminate the lease to take back the property. The purpose is to enable the landlord to end the lease if the tenant is in breach of any obligations under the lease. For example, the repairing obligation. So if you're not observing your repairing obligations, the property is getting derelict or is in disrepair, the landlord will want to seek that his property, which eventually he will get back at the end of the term, is kept in a good state and condition in accordance with the repair obligations. Therefore, forfeiture is the extreme remedy he can use to make sure he gets the property back in a good state, because what he will do is he will take forfeiture procedures to take the lease back. However, please note that there is a procedure which allows the tenant to apply for relief from the forfeiture. The clause, a forfeiture clause, is of concern to the funder because basically there's a risk that the lease may be brought to an end by the third party, i.e. the landlord, in circumstances. Now, the landlord quite reasonably will not agree to removing a forfeiture clause. It is a fundamental clause for protecting his property. However, there is a solution. The clause can be varied with the agreement of the landlord by including the ability for the funder to step in and remedy any breach, therefore securing the lease going forward. Typically, the landlord is required to give notice to the funder of any possible forfeiture action, and that gives the funder the opportunity to remedy the breach within a specific period, but thereby preserving the lease. So, for example, if there is lack of repair, the funder can go in and undertake those repairs and then preserve the lease. Now, turning now to alterations and building works, if you're getting significant funding, it's probably because you're going to do alterations and building works. The funding in the main will be to allow the club to undertake improvements and works to the facilities, perhaps construct a new pavilion, erect floodlighting, resurface car parking, internal refurbishments of the existing facilities, perhaps changing rooms, the clubhouse, construct an extension, provide grounds maintenance, storage perhaps, or a combination of any of those examples. The lease more often than not will contain a covenant by the tenant not to make any alterations or improvements to the premises. Now the covenant will be the absolute, thereby you cannot make any alterations at all, or a qualified covenant which allows alterations with the consent of the landlord. In certain circumstances, the landlord cannot unreasonably withhold such a consent. Therefore, you as tenant will need the consent of the landlord before undertaking the works, and the funder will insist on this, because otherwise you would be in breach of the lease if you haven't got that consent. This will entail providing detailed drawings and specifications to the landlord, which no doubt you'll have provided in any event as part of the funding application and any planning application that you need for the development proposed. The actual consent will be in the form of a legal document known as a license for alterations, and this will form part of the suite of documents in connection with the funding and will be dealt with as part of the process of the funding. Now the landlord, turning now to rent, the landlord may require an increase in rent to reflect relaxation of the restrictions, particularly if you've got a very restrictive lease, which then becomes less restrictive because of the variations to allow you to get the funding and undertake the development. Now, regarding local authorities as landlord, local authorities actually have a statutory duty when disposing of land to obtain best value, and that includes when granting a lease. However, there is scope for local authorities to grant leases for less than market value if the purpose for which the land is leased is likely to contribute to the promotion or improvement of the economic, social or environmental well-being of its area. So there is scope there for local authorities actually to grant you a lease at less than value. Turning now to the term. The length of the term remaining on your lease is crucial for funding purposes. The funder will require a sufficient length of time remaining on the lease, basically to cover the lifespan of the facilities provided by the funding. Typically 10 to 20 years will be required. If you have a lease which has got less than that, less than say 10 years, and it falls short for funding purposes, it's always open for you to agree a new lease with your landlord. In effect, that will be a new lease. You cannot extend a term of an existing lease because that is called a surrender or re-grant. It's a technical point. But if you're in that position where you want another 15 years or so, it's probably best to have a new lease. Well, you will require a new lease. And at that time, you can also incorporate any variations which will be required by the funder and negotiate those at the same time. So you may well have, say, a 30-year lease remaining, 30 years remaining on your lease, and that's fine if, for example, the minimum is 20 years. However, if you have a break clause in the lease, that will be problematical because obviously the lease can be ended by either the tenant or the landlord, giving you a shorter period than the length of time required by the funder. So next excuse me. Next slide, thank you very much. I must emphasise, all is not lost if you have a lease which is defective for the purposes of funding. As parties are free to agree a variation of the lease, so you can actually agree a variation of the lease with the landlord to incorporate provisions which will satisfy the funder and allow the project to go further. You'll usually find that local authority landlords are accommodating if appropriate protections remain in place. So therefore, step one, agree with your landlord a variation of the existing lease to address the funder's concerns. To provide comfort for the landlord, those variations can actually be limited just to the development you are undertaking and the funding you are receiving. So for example, if there was a clause prohibiting charging, the landlord could allow charging only in respect of the particular funding you're getting. It can give consent only to the works you are undertaking. So, you know, all is not lost. There are solutions here. If the lease term, as we discussed, if the lease term is not long enough, agree a new lease and incorporate any variations to address the funder's requirements. And generally, incorporating step-in rights, which generally won't be in your lease, isn't usually an issue for landlords, because in effect there's somebody standing there who potentially can remedy the breach, and they've still got their remedy of forfeiting the lease if that doesn't happen. So step-in rights in favour of the funder generally won't be an issue with landlords. I'd just like to touch on trustee liability here. The club may be an unincorporated body, or it may be actually a limited company, perhaps limited by guarantee or whatever. If it's an unincorporated body, it will need to be trustees on behalf of the club who actually enter into the lease. Now, the issue with that is that the individuals who enter into the lease as trustees are personally liable potentially as individual, and their assets are actually at risk if there is a breach of a covenant, for example, and the actions taken by the landlord and it requires the payment of money or whatever. Now, the solution is to limit the liability of the trustees to the assets of the club or the unincorporated body from time to time. And that's a fairly standard procedure, which a landlord usually will accept, because otherwise nobody would, as a trustee, would enter into the lease. So if you have a lease in place at the moment and it's with trustees, please check whether or not there's a trustee limitation of liability clause. If not, try and incorporate that into the lease. And going forward, of course, if there's any trustee is going to be the tenant, you do really need that in. And if you're well advised, that will be in the lease. Next slide, please. So, some top tips. This is all about really getting your ducks in order, because there's several things which need to come together. So you just will need to avoid slippage. So at the outset, check the status of your occupation. Do you actually occupy by way of a lease? If not, then you need to address that fairly early on. Check your lease for any problematical provisions, and also establish as soon as possible the funder's requirement regarding any lease provisions, and engage as soon as possible with the landlord. As part of the application, generally you will have to submit early on the form of your lease, and therefore hopefully everything will be picked up at that point by the lawyers, and then it can be addressed early on. And very importantly, understand the time frames. The funding may be available for a very limited period. How long is it for you to obtain planning permission? Does that fit in with the timescales of the funding? When does your planning permission expire? There has been situations where I've been involved with where the planning permission has been in place for a while, and it's coming to the end of the 4-year term. The funding has only just been agreed, and all of a sudden you're up against 3 months to sort the funding out, the legal documentation, before the planning permission actually runs out. And also bear in mind the process of actually agreeing legal documentation, because you've got at least 2 other parties are going to be involved in that as well. So hopefully that was useful, and I'll hand you over to Tim.
Thank you very much, Graham. Thank you very much, Graham. As I say, my name is Tim Rayner. I jointly lead the real estate disputes team at Irwin Mitchell. This second topic this evening is on the renewal of business tenancies. It's an important area. It's also vast, but I hope to give an overview as best I can in the time available. The renewal of business tenancies is essentially contained in one piece of legislation, and that's the Landlord and Tenant Act 1954. albeit there's tons of case law which essentially sort of fills in the gaps. So if I refer to the 54 Act, it's this Landlord and Tenant Act 1954 that I'm referring to. Next slide, please. So in terms of the structure of my section, I'm going to firstly talk about what rights it gives to tenants and the limits on those rights, the type of arrangement that the 54 Act applies to, what terms might be granted by the courts on renewal, how the renewal process is triggered, a few words on opposed claims. I'll explain what that means in a moment, and then I'll finish off with a few top tips, which I'll sort of discuss as I go along. So in terms of a sort of a short scenario, you might well have a lease of a ground and clubhouse. The contractual term of that lease, say, expires later this year in December, and you're concerned that the landlord might kick you out at the expiry of the term. You want to make sure that you've done everything you can to protect the club from that. As far as you know, the landlord hasn't served you with any notices as yet. So just have that scenario, perhaps the contractual term of the lease is expiring in December later this year. Have that scenario in your mind as we go through. So firstly, what rights does the 54 Act give to tenants? The purpose of the Act is to ensure businesses have the right to stay in the same property so they can carry on business. But that's subject to a landlord's right to terminate the lease in certain specific circumstances, and I'll come on to those in a minute. So it's therefore an Act which is for the protection of tenants, and that's always worth remembering. So in terms of the detail of those rights, it's essentially a bundle of two rights, and these are my sort of first two top tips, as it were. And those rights are the right for the tenant to remain in occupation until the tenancy is terminated by one of the ways under the Act. So the Act effectively continues the term of the lease, save as to duration. So for instance, if the lease, in my scenario, contractual term of the lease ends in December later this year, no notice has been served, then under section 24 of the 54 Act, the terms of the contractual term of the lease will continue, save for those relating to termination. And it will continue indefinitely or until it's terminated by one of the ways under the Act. So in other words, if neither party, neither landlord or tenant, take any action, the tenant in broad terms is entitled to remain in occupation on the same terms as contained in that contractual lease forever. All sorts of carve-outs and caveats to that, but that's the general rule, and that's sort of the cornerstone of the Act. So the second right that the 54 Act gives to tenants is the right to apply to the court for a new tenancy. In many instances, a business tenant will want to stay where it is. So you might consider sort of a Primark in a city centre, for instance, and if it wasn't for the 54 Act, at the end of the contractual term, obviously the landlord would have the tenant over a barrel, because no doubt Primark will want to stay where it is, and the tenant would have to accept the probably inflated landlord terms or go. So in effect, what the 54 Act does in some respects is kind of redress that unequal bargaining position. It gives the tenant a stronger hand when it comes to renewing its lease. So I've talked about what rights you get under the 54 Act. What type of arrangement does the 54 Act apply to? So in short, it applies to business tenants. So that's tenants who occupy premises for business purposes. So I'm just going to talk about two terms there. That's the definition of tenants and what's meant by business purposes. So in terms of that first one, tenants, the critical difference, and Graham's already picked up on this, but it applies to tenancies, not licenses, and that's a critical difference. So that distinction is actually a topic in itself, but generally speaking, tenants have exclusive possession, which means that they can stop the rest of the world coming in, or at least coming in as they please. Licenses, on the other hand, don't have that exclusivity of possession. A good way of probably just giving an example of that, you might consider, for instance, let's say a TM Lewin shop, where they can lock the shop at the end of the day, as compared to, say, a TM Lewin concession in a House of Fraser, where there is no exclusivity of possession. It's also worth saying that the label on the document isn't necessarily determinative. So it might say it's a license, that doesn't necessarily mean that it actually is. It's the terms contained in that arrangement that actually matter. Some terms will point towards it being a license, others towards a lease. What I'd say is, whilst the label isn't necessarily determinative, it is still important. So I think my sort of third top tip, as it were, is to dig out that agreement and find out exactly what arrangement you've got. The second term, so I've said that the 54 Act applies to tenants who occupy for business purposes. What does that mean? Generally, sports clubs have been found to occupy for business purposes, so there shouldn't be any issues in that regard. But that's not to say the issue shouldn't be overlooked. There's all sorts of reported decisions on what constitutes business purposes. But the legislation is quite clear that it's intended to have a wide range of, or to capture a wide range of business activities and trade. So, for instance, the occupying tenant doesn't need to be a profit-making organisation to qualify. It doesn't need to trade with non-members or be even a corporate tenant. Leases held by trustees can qualify, as Graham has already sort of alluded to. So if a tenant occupies for business, occupies the property for business purposes, then the rights that I mentioned at the beginning will apply, and the tenant will have the protection of the 54 Act. There's an important caveat to that, and that's the ability for the parties to agree that the 54 Act won't apply, and that's known as the contracting out procedure. And there's a very specific procedure that the parties need to follow if the lease is to be excluded from the 54 Act. In other words, the rights won't apply. And it's really important to first check whether or not that procedure was followed in relation to the lease you've got, because it makes a massive difference at the end of the day as to whether or not what rights you have at expiry. So really, that's my sort of fourth top tip, which is that don't agree to contract out of the 54 Act unless you're doing so on a fully informed basis. You are signing away considerable protection. There may be very valid commercial reasons why you're doing so, but just make sure you do so on an informed basis. So I mentioned that whilst the cornerstone of the Act is to protect tenants, I did say that there are some important limitations on that. And the most important one is that the landlord does have a right to recover possession if he proves one of the grounds under the Act, and I'll talk about that in a moment. It's also worth saying that in the same way that a tenant can refer the matter to the court if lease terms can't be agreed, so can a landlord. And the landlord might do that, for instance, if the rents are rising or if he wants to make changes to the lease terms. Important difference is that a landlord may be forced to grant a lease to a tenant, whereas a tenant can walk away even if a court orders one. But there may be cost implications if a tenant does that at a later stage. Okay, so I'm just going to talk briefly about what terms might be granted by the court on renewal. So the first question might be, well, why would a tenant want to renew? You might say, well, we want to remain in occupation. I've already said, actually, the 54 Act, if your lease qualifies, then that automatically continues the term of the tenancy on the same terms, save as to termination. So you might find that just doing nothing is okay for the moment. But clearly, one reason why you might want to renew is that you want to guarantee a longer period of occupation. You might want a 10-year lease, for instance. Another reason might be, and this might be of relevant to some clubs and not others, but you might want the rent might be too high, for instance. You might want the rent to be, you want to pay more of a market rent. Other reasons might be that you want to alter the terms to give you perhaps more flexibility. What I would say is, in almost all cases, the parties, the landlord and tenant, agree the lease terms. It's very rare. I've been doing this for sort of more than 20 years. It's very rare that a lease renewal goes to trial, but they do. But what I always say is that, you know, the merits of a claim and the strengths of a negotiating position are two sides of the same coin. In other words, you're more likely to succeed on achieving the terms that you want by negotiation if it's likely the court would order what it is you want in the absence of agreement. So that's just a bit of context as to why it's important to have regard to what the court might order should it get that far. And in determining what the court might order, the court will first have regard for the current terms, so the terms of the contractual lease that you've got. If either party wants to depart from those terms or make a change to those terms in the renewal lease, then they will be obliged to demonstrate why that departure or that change is reasonable. And there's a whole raft of case law around what a reasonable change looks like, and the court is balancing the landlord's rights and the tenant's rights. Lease renewal claims are in many ways like any other form of litigation. Here, in an unopposed claim where both landlord and tenant want the new lease but can't agree terms, the dispute is about the terms of that renewal. So if you want to change the terms, then you need to think about what evidence you have to demonstrate why that change might be considered reasonable. Rent is treated slightly differently in that the court can only order a rent which might reasonably be expected to pay, or that the tenant might reasonably be expected to pay in the open market. So this is a question purely of valuation evidence. There may be some complications around peppercorn rents, but I don't think there's anything to say that the court couldn't order a peppercorn rent if it was satisfied that a tenant might reasonably be expected to pay that in the open market. So I've talked about what the court could order. How do you actually trigger the renewal process? So the starting point, and often forgotten, is that parties can always agree lease terms without invoking any procedures at all. You don't have to serve notices in order to go to the landlord and try and agree a new lease. What the 54 Act does is give a regime to compel the landlord to agree a new lease if lease terms can't be agreed. So that's the ideal. Unfortunately, it assumes both parties play ball, which is probably more unusual than it is usual, unfortunately. And I think the main risk in just simply negotiating with the landlord without triggering the 54 Act, and I'll come on to the process in a moment, is just potential delay. If you negotiate having served notice, then you can immediately fall back on that formal process if the negotiations fall or take longer than you want. Whereas if you wait and serve notice later on, then you potentially lose a fair amount of time. So what is the actual process for renewing a lease? How do you trigger the process? So either party can trigger, by the landlord or the tenant can trigger the formal renewal process by giving notice. There are all sorts of considerations when serving notice. I think the likelihood is, and given time is short, the likelihood is if you're going to serve notice, you'll probably instruct a solicitor to do that, and I'd certainly recommend that you do. So I'm not going to go into the detail too much, but there's a few key points here. So firstly, the trigger notice or the notice that triggers the renewal can't be served more than a year out before the end of the contractual term. So it's really an end of lease process. To trigger the renewal, the landlord serves what's called a Section 25 notice, and the tenant serves something called a Section 26 request, and they're just named after the sections in the 54 Act. I think the key point here, the really key point, if you take only one thing away from my section of the talk, is that if you get a Section 25 notice, then it's crucial that you take steps by the deadline that is specified in that notice, and that the deadline will be at least 6 months from the date of the notice. And the steps that you need to take are to either apply to the court, extend that deadline, or agree the lease. So as a sort of my fifth top tip is, if you're a tenant, take action by that deadline. I think in reality, I'd strongly recommend that on receipt of a Section 25 notice from a landlord, you immediately take legal advice. If you don't, and if you fail to take one of those 3 steps that I've just mentioned by the deadline specified in the landlord's notice, then you lose the 2 rights that I mentioned above. And the first of those rights, if you recall, was the right to remain in occupation. So immediately the day after the expiry of that Section 25, the landlord could simply lock you out of the property. So it's a really crucial point that you take steps by that deadline, or I'd say better still, get legal advice on receipt of a notice. So if the parties can't agree lease terms, then obviously either party, as I mentioned, can apply to the court to decide those terms. I'm just going to say a few words on opposed claims. What do I mean by that? So the procedure that I was just talking about a minute ago is where both parties are agreeing that they want to grant the tenant a new lease, but they just couldn't agree on the terms. Opposed claims are entirely different to that. That's where the landlord doesn't want to grant the tenant a new lease. The landlord and tenant aren't moving in the same direction. So in terms of that scenario that I gave, so you've got a contractual term that expires in December this year. Perhaps this time you know that the landlord plans to sell the land to a developer, and actually you've received a notice from the landlord, Section 25 notice, and it refers to a ground F. What might that mean? So again, this is a topic big enough to not just fill the whole of this session, but a few days probably. As I say, the opposed regime is where the landlord doesn't want to. He's opposing the tenant's right to a new tenancy, and there are 7 grounds upon which a landlord can oppose the grant of a new tenancy. Some of them are very rare, but I'll go through them very quickly. Ground A, the property is in disrepair. Ground B, there are significant arrears of rent. Ground C, there's other breaches by the tenant. Ground D, that's where the landlord is prepared to offer suitable alternative accommodation to the tenant. Ground E is where the tenancy was created by subletting. And then by far and away the most common grounds are ground F, which is where the landlord intends to redevelop the property, and ground G, where the landlord intends to occupy the property for himself. Ground F and G are the most common, and of those two, ground F is the most seen, certainly. As an aside, if you receive a Section 25 and leave on the back of that notice, then you are entitled to compensation, depending on the ground specified, but certainly you get compensation if ground F is specified, and you'll get either single, the compensation is based on the rateable value of the property, and it's either the single or double the rateable value, depending on whether or not you've been in occupation for more than 14 years. So there's a lot of technicalities around that. The process for triggering the opposed procedure is actually the same in many ways as it is if in the unopposed. In other words, if a landlord wants to oppose the grant of a new tenancy, he serves a Section 25 notice. The notice looks a bit different because it specifies one of the grounds. But again, the key point is if you get one of those notices, the same issue applies, which is that you must take action by the deadline specified in that notice, otherwise you lose your 54 Act rights. In this case, the landlord has to prove his ground. He needs to prove that he intends and can redevelop the property, for instance, if he specifies ground F. If he fails to do that, then he is obliged to grant the tenant a new tenancy. If he succeeds, then the tenancy comes to an end. Just a very brief point, I think in those circumstances, the best thing often to do is ask the landlord for evidence of the ground. And then often it's a case of weighing up a cost benefit analysis of incurring costs in challenging the ground as against the benefits of staying. If the landlord's claim is weak, then he may be prepared to pay you more to get rid of you. If the landlord's claim is very strong, then it may be better not to hold out for too long. Conscious of time, so I'm just going to very quickly on the next slide rattle through the 5 top tips that I've already mentioned. So it's really a reminder of the 2 rights that are afforded by the 54 Act. That's the tenant's right to remain in occupation of premises until terminated by one of the ways under the Act, and the right to apply to the court. Top tip number 2 was dig out the agreement upon which you occupy. Is that a tenancy? Is it a license? Label isn't determinative, so get advice if you're in any doubt. If you are going to contract out, and it's obviously before you enter into the lease, but if you are going to contract out, make sure you do so on an informed basis. What are you getting in return for agreeing to contract out? And I think the last two can be taken together really, which is that if you get a Section 25, if I haven't already mentioned this, but if you get a Section 25, get legal advice straight away, but it's crucial that you take the 3 steps that I mentioned earlier by the deadline specified in the notice. Thank you very much, and I'll pass over to Ben.
Thank you, Tim. Good evening, everyone. My name is Ben Gilday, and I'm an associate in the real estate disputes team with Tim. I'll be taking you through the final slot of this evening's session to discuss telecoms leases and some of the implications for clubs when granting and renewing leases with telecoms operators. I'll keep this relatively brief and high level, as I anticipate that telecoms queries are not something which arise as frequently as some of the issues covered by Graham and Tim, and then we'll move on to the question and answer session, because I can see that we've got lots of good questions coming through. So by way of introduction to telecommunications, I thought it might be useful just to summarise some of the key issues and developments in the market at the moment. There's currently 33,000 telecom sites across the UK, and the combined market value in rent is around 360 million. So obviously it's quite a lucrative market and can be quite a positive additional rental income for landowners and occupiers, although as we'll come on to, rents have come significantly down recently. But more than ever, telecom sites are playing an increasingly prominent role in modern day Britain. Obviously they've allowed the economy to adapt and survive the pandemic, and the fact that we're all tuning in this evening working remotely is a testament to that. They're also going to play a key role in making sure Britain as a whole is competitive, which is obviously important following Brexit. But perhaps the most significant development is the recent launch of 5G. And as a result of that, the operators are all having to upgrade their networks and their infrastructure. So what we're seeing is a lot of operators approaching landowners and occupiers with requests to upgrade and install new apparatus. So that's something that's quite prominent in the market at the moment. But recognising the huge importance that telecoms play, in 2017 the government introduced a new code called the Telecommunications Code. And this is essentially a framework which sets out all the rules which govern everything in relation to telecoms agreements, from the terms of the agreements through to the termination and removal of apparatus. That's what we're going to be having a look at this evening. So amongst that backdrop, if a club is met with a request from an operator to install apparatus, what are some of the key considerations which the club should take into account? Well, the first point to note is that telecoms operators have their own security tenure under the code. So similar to what Tim was just discussing for business tenants under the 1954 Act, telecoms have their own discrete security tenure, which is very similar, but it's separate and it's under the code itself. And what it essentially means is that once a club enters into an agreement with a telecoms operator, the operator has the right to remain on site even once its lease has expired. So once the lease expires, it will continue on the same terms for an indefinite duration until the club follows a strict two-stage termination and removal procedure. And that procedure requires 18 months notice to be given, and the notice can only be given if the club can rely on one of specified grounds. So that would be that the operator is committing substantial breaches of its agreement, that it's persistently late in paying rent, or that the landowner, or the club in this case, intends to redevelop, or finally because the club would suffer severe prejudice that couldn't be compensated in money, and that prejudice outweighs any public benefit derived from the agreement. The operator would have the ability to challenge the grounds of opposition before the tribunal, so it could actually result in a full-scale trial on the opposed grounds for termination. And even if the club was successful in terminating the agreement, it would then have to follow the second separate procedure, which is to seek removal of the apparatus, which then requires a further notice to be served, specifying a reasonable period of time, which would have to take into account time for the club, for the operator to find a new site, to obtain planning permission, and then to decommission the current site. So conceivably, it could be about 2 to 3 years before you can bring about the termination and removal of a telecoms agreement. The next point to bear in mind is the level of rent that can now be secured for new agreements under the new code. We're generally seeing rents agreed at about 40 to 60% of the level that was previously agreed for telecoms agreements under the old code, so pre-2017. I know that one club, Aylesbury, has been in the news recently because it's having difficulties agreeing a new rent with EE. As I understand it, the rent paid under the current lease is around £6,000 per annum, but EE is now seeking a new rent of around £460 a year. And the reason for this is because the new code has introduced a new scheme of valuation, and that's how rents are now valued under the new code on the no scheme basis. And what that basically means is that no value can be attributed to the fact that the lease is a telecoms lease. So the very high value that was previously attributed to public demand for telecom services is no longer a consideration. So the tribunal will essentially consider if there are any other land uses for that particular site. So say, for example, in a recent case, London and Quadrant Housing, what happened here is that the rooftop site could have been used for solar panels. 6 additional panels could have been fitted in place of the telecom site. And the tribunal said that that would have equated to a rent of about £62 a year. But taking into account additional issues such as service charge, the tribunal then fixed a rent of about £5,000 per annum. Similarly, in another case, London Borough of Islington case, the tribunal found that there was no other possible land use for the rooftop site on top of a residential building. So taking everything into account, it fixed a rent of £1,000 per annum, which is frustrating for the landowner because it had provisionally agreed a rent of £21,000 per annum. It just didn't manage to get that agreed and finalised before the new code came into effect in 2017. But that goes to show just how significantly rents have fallen under the new code. So what about existing agreements and the renewal process, which applies when an operator is already occupying a site? Well, there has been a huge amount of litigation since the new code came into effect in 2017. It's now an incredibly contentious area, and already in 3 years there's been more cases under the new code than there ever was under the 30 years of the previous code. But in very brief terms, the lay of the land is now being settled, and what the tribunal has said is that if operators don't have a formal lease in place, so if they're occupying under a tenancy at will or a license agreement, then they don't actually have protection under the code. And in this case, a club could basically seek immediate removal of the operator. So say, for example, that would make the negotiation process a lot easier. But if there is a written lease in place, then it depends on whether the 54 Act also applies to that agreement. So that's the 54 Act that Tim was just discussing. It's essentially in either case, though, whether the 54 Act applies or not, if there is a written agreement in place, it requires 6 months notice to be served on the operators, and that notice can only expire after the existing lease has expired. So in other words, when the lease is approaching the last 6 months of its term is when a notice can be served on the operator proposing terms for a new lease. But obviously, given the rate at which rents are coming down, a lot of landowners would take the view that actually they don't want to rock the boat and they would leave operators in occupation on their existing terms for as long as they can. And then just one final point, which I'll finish on, is that if there is telecoms apparatus in situ and the club is unclear as to who owns the equipment, there is a process under the code whereby we can serve notice on the operators and they have to respond within 3 months to confirm that they have the equipment there and details of any rights or agreements which are in place. So obviously, if there's any signs on the apparatus as to who it belongs, then we would know who to serve the notice on, and then we could take it from there, serve notice, and find out the relevant information. So that's a very high-level run-through of some of the issues which are relevant when considering granting a telecoms agreement. There's been lots of questions, so I think we can move on to the question and answer session in relation to all of the topics covered this evening. I will start from near the top. So there is a question from Paul from Ellesmere Port Rugby. I think this is a question for Tim. He says, we play at Whitby Sports Club and the grounds are owned by Shell UK, who lets the club have use of them for free for the community. Shell has only given the club a 30-year lease, which means we can't get RFU funding for anything. We have asked Shell to give us a longer lease, but they won't commit. Any ideas?
Thanks, Ben. Thanks, Ben. I think the short offer, it's in terms of the 54 Act, obviously, as I mentioned, the sort of the right to renew and get a longer lease only really applies in the last year of the term, and that's the only way that you could compel them is by serving a section 26 in the last year of the term. I'm not aware of any other way that you could compel them. There certainly isn't under the 54 Act. I don't know if Graham, you've got any other thoughts on that. But so far as you are in the last year of the term and the lease is inside the Act, then serving a section 26 would be the way to bring them to the table and start talking about a new lease.
The only point I would mention on that, Tim, is if it's 54 Act renewal, what's the chance of actually getting a 30-year lease on renewal?
Yeah, does it come back to me? Yeah, the maximum that the court could order is 15 years, isn't it? Absolutely right. But as I sort of mentioned at the outset, but it sounds like the negotiations may have stalled, but there's nothing to stop parties from agreeing a lease outside of 54 Act.
Okay, thanks Timmy Graham. The next question, John from Wythenshawe. We are in the process of leasing the pitches. Yeah, sorry, John, on this one, we may have to come back to you on this one separately offline, just for a couple of reasons, if that's okay, so we can pick that up with you separately. So I'll just have a look at the next one. So Dave, I think this was an RFU specific one on what funding avenues are being referred to. Do you want to pick that one up, Dave, or should we also deal with that one offline?
No, I can just give a quick overview. It's nothing specific. I think in answer to the question, you're quite right. Currently, at the moment, there's quite a lot of funding avenues that are closed down because of COVID. A lot of the conversation in terms of and the direction of travel in terms of this webinar is sort of looking for the future and planning for the future and making sure that you're in the right frame. So I'm not talking about any specific funding at the moment, but obviously, hopefully, we will get back to some normality shortly, and the funders will start funding again. Therefore, security of tenure and lease, and that will be very important. Okay, thank you, Ben.
Okay. The next question, Graham, I think this might be one for you.
Yeah, I could pick that up.
Yeah. Yeah. So,
okay. This is actually potentially a classic situation whereby the club may have taken a lease many years ago, and then you have either trustees who entered the lease on behalf of the club. Some unfortunately may have died. Some are now probably old and not really involved in the club, and as you say, live some distance away. Basically, the legal interest in the lease still remains with the original parties. So if you have, say, 4 trustees, and there's only 2 who are really actively involved now, you can actually assign the lease, that's transfer the lease to new trustees. So they're the people who are actually active at the moment. That'll have to be with the consent, obviously, of the existing trustees. And most leases, well, a lot of leases will actually allow that as a matter of course without getting consent to transfer, because it's a classic. If you've got 30-40 year lease, there's some people unfortunately are not going to be there in 20 years time for one reason or another. The difference between executive committee signing or the trustees, anybody who's appointed can be a trustee of the lease. It doesn't actually have to be anybody on the actual committee who runs the club. So it's whoever is appointed under the proper rules of the club to be the tenant. So if you've got a new lease coming up, you can actually appoint people to be trustees. They'll not necessarily have to be members of the club as well. You can have other, and then how they deal with the property is actually set out in a trust deed. The executive committee perhaps may be actually signing other contracts, which is fine if they've got the authority to do that. But the lease is just specific trustees who the club agree will be the trustees.
okay, thanks, Graham. What provision enables local authorities to let at less than the market value?
I could pick that up.
Yeah.
Yeah. Yeah. So the hi, am I online? Yep. Hi. Sorry about that. Yeah. So basically, the Local Government Act 1972 sets out that local authorities have got to get best value. However, the Act also allows the Secretary of State to issue general consents which allow disposals at less than market value, and there is in place a general disposal consent for England in 2003, which is the one I alluded to in my part. There's also a consent in 2012 for London. So that's where the statutory power arises. It's basically to stimulate economic development or well-being of people in the area. So you may well fall within that category because it's a sporting facility, which is all to do with well-being. But it will depend on the local authority's strategy for that. So there is scope there.
Okay, thank you, Graham. Tim, I think this is one for you.
Yeah.
Is the 54 Act designed to put the emphasis on the landlord to renew?
Thanks, Ben. Good question. I think it's fair to say that there's an equal emphasis because either party can apply to the court to renew, and that was a sort of a shift. So yeah, landlords can force through renewals, as it were. As I mentioned at the outset, tenants can ultimately walk away. But I think in terms of the question, I think there's an equal emphasis.
Okay, thanks, Tim. I think this is also a good one for you, Tim. This is from Paddy. If you had security of tenure and applied to the court to grant a renewal, are terms likely to be subject to change, particularly in respect of rent? Also, would your advice be to negotiate a new lease or apply to the court for renewal?
Thanks, Ben. Another good question. I think unfortunately it's an impossible one to answer as to whether or not terms are likely to change. What I would say is, I mentioned in my part of the talk, whoever is wanting to change, the onus is on them to demonstrate that the change is reasonable. Rents, certainly in the commercial arena, are changing significantly at the moment, but it is very much a evaluation exercise, and also the rent will be dependent on what lease terms might change as well. And as to whether or not my advice would be to negotiate or to apply to the court, I think I would always say that if you can negotiate without sort of getting contentious, then that's going to be the ideal. The problem is if you negotiate for months and months and months and get nowhere, then you may well feel that you'd wish you'd triggered the renewal process and served notice, or even applied to the court sooner and not lost time. So hopefully a bit of an answer, even if it was a bit vague on that, but good question nonetheless.
Okay, thanks, Tim. I think you're Mr. Popular, Tim. This is another one for you. Are leases for bare land and is a peppercorn rent? If we significantly develop the site, can the landlord significantly increase rent on the lease renewal based on it being a developed site?
Again, I feel like Boris Johnson, but another good question. I think the answer has to be that it's likely to significantly increase the rent. As I mentioned in the talk, the court can only court's only got a jurisdiction to ability to order a rent that might be reasonably expected to pay by the tenant in the open market. So if what is being valued is significantly different to bare land, then it seems to me that the rent will go up significantly as well.
Okay, thanks, Tim. I should flag that we have hit 8 o'clock, but well, we're happy to stay on for 10 or 15 minutes or so just to run through some more of these questions. So let's move on to the next one. I suspect this might be one for you, Graham. If we purchase or are gifted our rugby club, and grounds the landlord may wish to put in place an overage clause, what is meant by this and how would it affect us in the future?
Yeah, I can pick up that. I think actually what we're referring to is an overage clause, which is probably better defined as a clawback provision. So, for example, if it's open land and it's a recreation land, and you've been gifted the site and you own the freehold, what the person selling this site will be concerned about is that you'll have the freehold and perhaps you could develop it for other purposes and, for example, sell part off for housing, and therefore you'll get a substantial capital receipt. And his concern is, well, I've given you the land for a specific purpose and you've got rid of part of it and obtained a massive capital receipt. So that additional sum is known as overage, and it's generally protected by way of overage provisions. In short, is whereby if you undertake certain development outside a prescribed set of circumstances, so you use it for other purposes than a rugby ground, you get planning permission and you develop it or you sell it off, that the original seller wants a percentage of that profit. So if for example you made £200,000, you might want 30%. So that's what that's all about. It's about protecting land which has been given for less than value and is to reflect what it was given for, and then it's used for another purpose. Generally people say, well, why don't they put a restrictive covenant on it? The problem with restrictive covenants is, and this is a bit of a legal point, is it's nothing to do with the commercial arrangement whereby if you sell the land on, I want a share of the profit. That's a commercial personal arrangement, where a restrictive covenant affects land. And generally the covenant has got to benefit of the land. Well, if there's no land which has been benefited, the covenant, the struggle to enforce the covenant, or indeed any sum for releasing that covenant, will be substantially potentially less than a share of any development value. So it's quite a proper point they're putting forward, actually. So basically, in
Okay.
the future, if you were to sell the land or part of the land, you have to pay a percentage back of that profit.
Thanks, Graham. Tim, I think this is probably one suited to you from John. In 1996, the trustees of the club signed a 5-year lease with an Oxford College on 6 acres of land, a pavilion and a 2-bedroom cottage. The lease was renewed several times. The latest renewal was in 2011 and expired in 2016. The previous chair of the club wrote to the college several times with little reply. Finally, in 2018, they agreed another 5-year lease, but despite many emails, they have not presented one to us. I suspect that question might be, what can they do now, possibly?
Yes, thanks, Ben. I think that is, isn't it? So it looks like the contractual term has expired. So you'd be in a position to, if you want to trigger the renewal process, then you'd serve a Section 26, setting out what terms you want. And going back to my sort of top tips, make sure you get some, well, you would probably want a lawyer to serve the Section 26, but obviously you need to make sure you take steps by the deadline that's specified in that. But in short, yeah, in terms of the way to push it on, it sounds like the best way would be to serve a Section 26 request.
Okay, thanks, Tim. I think this one is staying with you in the spotlight. From Paddy, what is the position if no Section 25 or Section 26 has been served, but the landlord continues to collect rent?
Yeah. Coming over to me. Yeah, thank you. There's no problem actually with, so again, going back to the sort of the cornerstone of the Act, if no notice has been served and the lease is inside the Act, then the lease will just simply continue, including the entitlement and obligation to pay rent. So there's no issue, and the rent that will be paid or payable in the absence of any notices will be the rent under the terms of the lease.
Okay, thanks, Tim. Graham, I think this might be a good one for you. Is it possible, this is Nigel's question, is it possible to have a suitable lease when we share facilities, grass and changing rooms, no absolute possession either across the year or even, that means on a daily basis?
Yeah, what can happen is you can structure a lease arrangement or otherwise around a joint user, but perhaps that's something which we should sort of deal with offline.
Okay.
We're happy to do it.
Okay. So a question from Paul. We currently operate under a license from our local authority, but they are happy to enter into a lease. We have just registered as a CIC. Who enters into the lease for the club?
I can pick that up. Hi. Yes, usually it would be the CIC who enters into the lease, and again, you may have underneath that the CIC regulations regarding the use, but it would be the CIC who enter into the lease. If you're operating under a license at the moment, I assume we're now negotiating a lease, and then the CIC can enter into the lease. It depends upon the structure of that CIC, but generally, yes, that can enter into the lease. It would be the best body to enter into the lease. You need to take advice, depending on the structure underneath that. Okay,
thank you very much, Graham. Tim, I suspect Noel's question may be one for you. There's 4 years left. They need funding for major projects. They've been offered a new lease, 30 years, but with 5-year break clauses which don't work. What can they do about this? Also, the time delay in response from the landlord. How can we get a response from them?
Yeah, thanks, Ben. I think, unfortunately, I think this is the similar question that we've had earlier. You're not in a period where you can, under the 54 Act at least, force the landlord to agree a new lease at the moment. So I think certainly from a 54 Act, there isn't really any angle here. Graham, I don't know if you've got any other thoughts on that one.
No, not really. Well, I suppose if the break clauses have passed, I've got 4 years left. Yeah, you're really in their hands until you get to the point where you can actually start under the 54 Act. And the problem with the 54 Act will be the maximum of 15 years. So it's going to be a case of negotiating with the county council. I wonder if there's any scope in approaching councillors to get them to the table.
Yeah, I think I was going to just say, it's come back to me, but I think that may be a case of using commercial rather than legal levers. It sounds like.
Okay, thank you both. Just move to a question from Noel. Why would the landlord contract out of the Landlord and Tenants Act 54? What's the benefit to them?
Definitely one for me, isn't it, Ben?
I think so, yeah.
A good question. I'll deal with it very briefly because I'm just conscious of time, but effectively a contracted out lease is far better for a landlord in terms of the flexibility, because when the contractual term expires, the tenant has no security after, and there's no remit for the tenant to apply to the court for a new tenancy. So there are significant advantages from a landlord to have a contracted out tenancy.
Okay, thanks, Tim. I think we may have to wrap up, but I think possibly there may be time for one more question, do we think? So let's have a look. The next question is from David. We are currently renting and the lease, the current group is coming to an end in 8 years. As they look like they are going to cease as a group, how could we as a club move to take over that lease from them and extend it without going to open market?
I could pick up on that.
Graham, do you? Yeah, Graham, if you don't mind, thanks.
Yeah, so I'm getting that there's a group which are actually the tenant, and then the club may be part of that or a separate entity. It's possible to assign the lease, that means transfer the lease, to the club, and you'll have to check the lease, which might allow the lease to be transferred, but if it does, it will be subject to certain conditions. So have a look at your lease. If there's a total bar on transferring the lease, then you'll have to negotiate with the landlord. But if there's the ability there to assign the lease, i.e. transfer the lease to another party under the lease, then that could happen. Even if there's a total bar on that, you can still talk to the landlord about assigning it. And then when it comes to the end of the lease, depends if you're contracted in or out, as Tim referred to, then you could apply for a new lease at that point. Or negotiate a new lease at this point if the other group is prepared to end the lease at this point.
Thank you, Graham. I think just to wrap this up, because I'm conscious that it's 8:15. Firstly, just to say that if we haven't managed to get to one of your questions this evening, and there were some really good and lots of them in the system, we'll take those away and hopefully get some answers written down and sent out following. Obviously, the webinar this evening has been recorded and will be made available on demand following this event. And it really just leaves me to say a massive thank you to my colleagues at Irwin Mitchell, who've given up their time this evening to take us through, which is well, I find it a very difficult subject, but and obviously it's a very large subject, but I thought they've done a fantastic job to give us some top tips and to point us in the right direction. Please don't forget to make sure you use some of the resources that we've got available there that are on the screen at the moment. And hope it leaves me to say have a good evening and see you again soon.